Welcome back, everyone. I will go ahead and get us started. It is 1:02 p.m. This is the afternoon of phase 3 of the hearing in the court reference proceeding in the case of City of Marina versus RMC Lonestar, Monterey County Superior Court case number 20CV001387. We're picking up where we left off, dealing with the admission of exhibits for phase 3 into the evidentiary record. And I believe where we left things before we broke for lunch was I was turning to MCWD and their exhibits. I first will turn to either Mr. Brochard or Mr. Wilkins, the appropriate person to offer Marina Coast exhibits into the evidentiary record. And if you would please identify the number range or the specific exhibit numbers. And then we can turn first to CalAm's October 4th motion to strike phase 2 and phase 3 testimony of Dr. Kincaid, and there was a response from MCWD that I also received, I believe, on October 10th. But first, I will turn to you. Looks like Mr. Brochard, at this time, would you like to offer Marina Coast Water District's phase 3 exhibits into the evidentiary record?
Yes, we would like to offer in exhibits Marina Coast 163 to 169. And then 171 to 178. And then exhibit 175 and 176 were the summary slides, and there were 2 revisions. So we'd be moving in the second revised slides.
Thank you for that clear description. All right, with that, I would like to turn to CalAm's October 4th motion to strike, which I have read carefully and read the district's response. I think, unlike my treatment of the objection to Mr. Tietz's testimony, I think this one, as I understand it, it's really a cumulative argument by CalAm. So I think it makes sense for us to not to try to break it down, but really talk about it as one broad motion. Does that make sense to you, Mr. Betts, or do you have any different thoughts about that? That's what I viewed it as. Really, it's a cumulative argument, but does that make sense to you?
It makes sense. Yes, thank you. And I'm prepared to respond to the opposition.
Well, let me first say there was one issue in the opposition that I think deserves clarification from me, which is that MCWD appropriately raised the objection on the basis of timeliness, specifically, I believe it was a footnote 1, on my procedural ruling of October 4th. Now I'm going off of memory because I don't have my notes in front of me, but I believe my procedural ruling of October 4th, in which I said that I would accept any additional evidentiary objections to rebuttal testimony, and I specifically said rebuttal testimony. And MCWD raised this and said, well, that's, you're objecting here to direct testimony by Dr. Kincaid, so this is untimely. And I think my statement in the October 4th procedural ruling was just an error, that I mistranslated what I intended and what I said during the hearing. I went back to the hearing transcript to refresh my own memory, and that seems to fit, because I don't think I intended to limit the objections to specifically rebuttal testimony. I think that crept in because the objection to Mr. Tietz's testimony was to rebuttal testimony because he only testified in rebuttal. And so that did come in. So I just wanted to make that clarification. I recognize that's what the word said in the procedural ruling. That was not my intent. So I'm not going to exclude or limit or not consider CalAm's objection on that basis. And that was my error in essentially transcription when issuing that ruling. So I apologize for that. I think first I'll turn to, I guess it makes sense, Mr. Betts. I will turn to you, of course, Mr. Brochard. I want to hear from you as well, and we'll go back and forth. But maybe it makes sense to give Mr. Betts a first chance to respond to the response. So go ahead, Mr. Betts.
Thank you very much. And as usual, thank you for your time and attention to reviewing these. So I'm not going to repeat what's in the papers, but more direct my response to the opposition points, for which I have or had 6 points. The first issue was there's an argument that the motion was unsupported by any legal authority, but we respectfully disagree. The motion was grounded in Government Code 11513C, which at some point I should probably get tattooed into me because we've talked about it so much, but that does specifically provide the grounds for this. So we do not believe we needed to rely upon Sargon and its progeny, which I've said often throughout today, I wish we could rely upon. But Government Code 11513C does tell us that relevant evidence can be admitted if it's the sort which responsible persons are accustomed to rely upon in the conduct of serious affairs. And collectively, as you have seen from our arguments, we say, given the admitted errors, the admitted uncertainties, and the admitted violation of the rules, collectively that body takes it out of any admissible standards for this particular proceeding. And certainly if Sargon applied, we would submit there is no court in this country that would allow this type of testimony in. As it relates to argument 2, which was timeliness, you did address that, but I also just wanted to note, we weren't ignoring any of your rules. We've read them very clearly. And in fact, we're relying upon a September 26th transcript, page 4, lines 6 through 21. I think at one point you did indicate that we could provide additional challenges based on motions. I know you've addressed it, but we wanted to be very respectful to you and let you know that we have observed your rules, and by no means we're trying to obfuscate those. My third issue goes to the substance. And here, even in the opposition, which was very defensive, they concede time and time again that there is a parade of errors by Dr. Kincaid. And the way that they go about explaining it is, I think on the opposition, page 6, lines 27 and 28, and they say in general that which they call corrections reflect Dr. Kincaid's commitment to producing a reliable model. And I paraphrase that. I certainly didn't get it right. But being a swell person or a nice person trying to get the right result isn't the standard for anywhere. I mean, he may very well be a good person or not, and he certainly presents well, but just because he tried doesn't exclude or make really serious errors into admissible testimony. The next issue is they say that he ran out of time, and that was one of the explanations for the error. We see that on page 6, lines 1 through 3. But what they ignore, our experts all had the exact same amount of times as theirs did, and I think, we would submit, did twice as much work. Recall, we keep doing the models, and they keep poking holes in them. So we met all our deadlines. We met all of our timeframes. So the excuse that he ran out of time and therefore did inaccurate work is not a justification. As for 3 errors that they admit and try to explain away, those 2 don't justify admission of his testimony. They admit that he made errors with respect to reference points for elevations for the 3 project wells, but the answer is that he later on resolved it. But there's no explanation of how he resolved it, why it's reliable, and what he did. Similarly, on the errors for the translation heads in the June 12 steady state model, the argument is that the errors were there, but they lay the blame and say our experts should have told them, or told us, I guess, that their model better fits the scenarios here. But there's no explanation of why there are errors, how they were fixed. It was just an answer that our experts should have told us that they got it right. And I promise you, after a decade plus of doing this, our experts are not telling us that they got it right. We consistently provided testimony showing that their testimony is wrong, the work that they have done. But there's no explanation of why their conceptual understanding of seawater intrusion is more, not less reliable. It's just attorney statements. Similarly, with regards to the errors on the distribution of pumping, they admit that they used a different distribution of pumping percentage than what the AAO previously ordered, the 44-56 split. Again, no explanation of why they made that error, what they did, why they deviated, or somehow how they fixed it at the end of the day, other than they do say, as they had to, it was based on a miscommunication internally. But you have this parade of errors, some of which they didn't address, many of which they did address, with no explanation of how they fixed it or how it relates to these proceedings. My 4th issue, which is the biggest issue, is the considerable uncertainty. We had Dr. Kincaid admit under oath, under my cross-examination, that a lot of his work has considerable uncertainty. And that's when we get into whether it's Sargon, by the government code. Expert testimony predicated on uncertainty can't be admitted and isn't admitted everywhere. And what I found really interesting in the opposition, on page 8, lines 12 through 22, they identify 5 other areas, I think, at least 5 other areas where Dr. Kincaid admitted that his work is uncertain. So not only do you have all the issues about which we have been complaining, about which I cross-examined him, they give us 5 other areas where he's admitting that his work is uncertain. That by itself, we respectfully submit, under any standard, renders his testimony inadmissible. And the only response to that, again, they concede it was uncertain. They give you 5 more examples while it's uncertain. They complain that our experts, on the other hand, have been very steadfast that their work is correct and that will, at the end of the day, they've demonstrated that there's no harm and that we've been consistent about that. Unlike their experts that are saying that their work is uncertain. And let me absolutely confirm, we stand by that. Our experts for over a decade have done work time and time again, revised modeling, and it's almost whack-a-mole. Every time the city or MCWD has brought up an issue, they've addressed those issues. And that has resulted in several models and several changes, and every single time it has led, we believe, to the same result, that there is no harm here. So you're absolutely right. They are absolutely right that we stand by that position. And in fact, I think that's in part why Mr. Osias earlier today welcomed all of our models and our file inputs and anything to be open to the world, open to the public, and exhibits. We're willing to have everything we've done tested. And we want their work tested also from other people. But the point that their work is uncertain and we claim that our work is certain, gives grounds to excluding their testimony, but does put an exclamation point. A lot of what we were doing is that every time we do this again, our work does come up with certain results showing that there's no harm. My 5th point goes to the violation of the rules. They admit that they abandoned certain parameters, model layer 1, and there's no question that they did. And the answer is, as in part what Dr. Kincaid said, he felt it became less important. But I could tell you there's all sorts of stuff that we think are less important, but we came to an agreement of what we were going to do for phase 2 and phase 3, some of which we didn't want to do. We thought it was totally unnecessary, but we had rules. We abided by those rules. They didn't. It's just as simple as that. And just saying that they didn't feel something is important doesn't make grounds for ignoring what was previously agreed upon. So in sum, as you touched on initially, the cumulative effect of the parade of errors, the admitted uncertainties, the violation of the rules, all render, we respectfully submit, his testimony inadmissible and move to strike it. This is an important proceeding. It's a project that's been repeatedly approved. As Ms. Meisenheimer identified earlier, it's very important, but it shouldn't be resting on testimony that's uncertain, riddled with errors. That's our response to their opposition, and for those reasons, we stand by our motion to strike. Thank you.
Thank you, Mr. Betts. I have a question for you, which it really is a question that goes to your closing brief. So I'm about a month early, and it's a little bit unfair to ask you a month early, but here's the question. I'm going to try to articulate it. Frankly, I was surprised by your motion because just from my role in listening to and reading the testimony and listening to the hearing to date, and then being fully immersed in the proceeding in phase 3, what has struck me is that the model results are pretty close from a non-expert's point of view, right? They're pretty similar. That's really interesting. One argument that CalAm might make is to say, well, look, Dr. Kincaid came up with this, our experts came up with this, and look, they're pretty close, and we win, right? It doesn't matter. Here's the bookends, and we win. So I thought it was interesting that to file this motion, and maybe to put a point on this, you raise the issue of uncertainty, and Dr. Kincaid does admit to the uncertainty in the MCWD model. He also has a substantial testimony about what he perceives as the same uncertainties, many of the same uncertainties being raised in CalAm's modeling. So to some extent, I'm thinking if the uncertainty that Dr. Kincaid raised with respect to MCWD's model is enough to throw it out, wouldn't it be enough to throw out CalAm's model? That the same arguments should apply. So I'm just wondering, and like I said, I'm admitting this is a little bit of a closing. This is not directly relevant to the standard of admissibility for Dr. Kincaid's testimony. But I do think it would help me if you would humor me. It would help me understand CalAM's approach to this issue, what we do with models. So I'll continue my rant. Uncertainty is the challenge in this proceeding, right? Models are models, they're limited, they have limited utility. How we are going to articulate to the court in a thoughtful and as correct as possible report of referee that, you know, this is the conclusion of the board, but models are models and there's inherent uncertainty. That is the challenge in this proceeding, right? I mean, that is absolutely, you've been wrestling it for longer than I have, and I'm coming in and I can see it. So this is the challenge. It's coming up in these evidentiary motions. It's going to come up in your closing briefs. It's the big thing. So I'm wondering if you have any comments you think that might be helpful for me in my thinking right now about how the AHO should deal with uncertainty and uncertainty in all of the models.
Sure.
Do you have any comments on that?
I do.
This is unfair. So I realize it's premature. You'll have a chance to really tell me in your closing brief, but I'm asking you now.
I have 3 comments. Number 1 was when you talked about, yeah, let's bookend this. The models are generally the same, therefore we win. Yes, and I'm not saying you saying we win. You bet that's what we think. Number 2, Mr. Osias, I want you to breathe and not worry about what I'm going to say. And number 3 is that the issue of uncertainty, I think you're right. There are a lot of similarities in the models, which is pretty telling, and some we'll be making arguments on that. The uncertainty I take issue with is on the conclusions, is what do these models tell you? And so we are certain that the decade plus of models that have gone before the State Water Board, the PUC that have been addressed by the PUC and the CPUC, and in this proceeding all show there will be no harm. And that is, to us, unrefutable. It's been demonstrated umpteen times. They, on the other hand, what I'm challenging is when Dr. Kincaid said, I think in large part is uncertain what's going to happen. And if this goes way back, if you look at Dr. Trudell's cross-examination from the first proceeding, they're saying, we don't know what's going to happen. And I encourage you to take a look at that. And that's a real common theme that we keep hearing, whether it's in this proceeding or other proceedings from Marina Coast and MCWD. They just say, we don't know. We don't know. Whereas we're saying, for sure, we know there will be no harm. That's the uncertainty on channel that I take issue with. I think our models are certain. I think the work is extraordinary. It's the conclusions, I think, that we take issue with. Mr. Osias may, now that he has had the opportunity to breathe, comment on that. But those are my thoughts, and I trust Mr. Osias will concur with some.
So
Mr. Osias, you're welcome to chime in.
Yeah, thank you. And I acknowledge also that you didn't invite me to make a closing argument, so I won't. Although I'd like to, but it's premature. Because as I said this morning, I haven't written it yet. But there is a conscious and prevailing theme in the testimony about among the 2 sides. And I'll say about the 2 models, but it goes beyond the 2 models. And that is on the Marina and MCWD side, they're focused on predicting the future. Okay. At their suggestion that Sigma will change the future, let's predict the future with hypotheticals about Sigma. Let's predict the future about a hypothetical GSP in the Monterey Basin, et cetera. Okay. Let's look at a modeled future and try to explain why in 25 years a line moves. You've seen or heard some of that. What is CalAM's focus? And I mean, not just focus in the case, which is correct, but also focus in the models. And that is, what impact, if any, does the project cause or not? That's a different question. And although maybe CalAM's model about the future in 25 years or 64 years and where the seawater intrusion front is or isn't going to be without the project has a degree of uncertainty, the comparison of with and without the project has a different uncertainty profile. It's far more certain about what the effect of the project is under the CalAm model. And so as you know, and have heard from all the experts, you start with what's the purpose of the model in terms of evaluating the output of the model. I mean, again, I'll be silly from this morning as an example. If you said, well, what does the model say about traffic patterns in Monterey in 35 years? I don't say anything, but if it said anything, it wouldn't really matter because that's not the purpose of the model. Okay, so I remind you of that. So the other thing I think is on the point you raised about two models. The models have overall similar outcomes. They get there in very different ways. And you shouldn't assume they're equal dignity just because at the end they get there in the same way. One is more probable than the other, for sure, in the opinion of our experts, and frankly, I guess in the opinion of their experts. And so it's not irrelevant, the modeling approach. And one side did far more sensitivity analysis than the other. That would be CalAm side, and one did far more calibration efforts to keep adjusting stuff at the beginning of the model to get to a result they liked. That would be the other. So that'd be an argument for sure. But those are the two main points. It's not worthy of ignoring the differences in the models in terms of how they get to a result, but more importantly, what's the focus and how does that focus relate to the uncertainty question? Okay. And no one's going to put in their papers that you can model either the impacts of the project, our focus, or the future of the basin with 100% certainty. And Yogi Berra has a very famous quote about predicting the future. I think he said it's difficult because it's the future. It's pretty obvious. But the probabilities of the project changes versus the probability of, what Sigma projects are going to be implemented and how much farming is there going to be and how much urbanization and all that, that's far less certain. But it doesn't necessarily, this is where the rubber hits the road, doesn't necessarily change the project impact. Okay.
Thank you, Mr. Osias. I think, Mr. Brochard, I'll certainly give you a chance to respond, but I also see Ms. Meisenheimer. We've now, I think it's fair to say we've strayed beyond the strict scope of this motion, so you certainly will have a chance to chime in also on this general topic of conversation. But I will turn to you, Mr. Brochard.
I'm not even sure what you'd want me to respond to in all of that. I'm not sure Mr. Osias addressed anything related to the motion.
I did invite it, so it was, I think, fair.
If you have any questions, I think that would be easier. I would like to correct, I mean, I could say a lot in response to what Mr. Betts said, but I'll start small. I think he had said the AHO ordered that the slant well distribution be 4456. That's not correct. The AHO didn't order anything. And I think the issue was originally raised by Ms. Graziano, who didn't understand why it was done that way, because as Dr. Kincaid explained in his testimony, an arbitrary distinction of 4456 distribution between the slant wells is not correct. It should have been done based on the transmissivity in the models, which is how Dr. Kincaid and his team did it for the future scenarios. And that's why they did it that way. And I think that's explained in the testimony. Mr. Betts said that there was an issue with the slides and the reference points for the wells. Dr. Kincaid did explain that. It had to do with the NAV. He explained both his live testimony and his written testimony. The translation of the heads between Mr. Durbin's model and the Marina Coast model has been explained in written testimony and in live testimony multiple times. The fact that there was a problem also wasn't a complete surprise. The difficulties that were going to be inherent in using Mr. Durbin's model were discussed in multiple status conferences. The April 24th status conference, the automatic transcript is on the AHO's website. And if you just start at timestamp 4137, and then go to 4414, you'll see Dr. Kincaid explaining to Mr. Lilly that Mr. Durbin's model is a texture model that just looks at coarse and fine grained materials. It's not a layered model, so it doesn't differentiate specifically between aquifers and aquatards, such as the models that CalAm and Marina Coast team put together and were submitted for the drawdown and the transport analysis, which is why the translations, you couldn't just simply take something from Mr. Durbin's model and plug it in at an XYZ point in the layer models, because what Mr. Durbin may think is the middle of an aquifer may not be the middle of an aquifer in the layered models. And Dr. Kincaid's explained that multiple times. Even Mr. Durbin acknowledged in his testimony that the translation problem was just a mechanical error and not a big deal and was fixed. Dr. Kincaid also explained that the difference in the calibration was done to balance the ocean inflows. And I guess we will spend time on this in the closing briefs, but Mr. Durbin also spent quite a bit of time explaining that he made changes to mountain front recharge that were wildly different than his prior estimates, specifically for the purpose of trying to control ocean inflows in his model. Everybody kind of assumed, all of the experts kind of assume that there's a specific amount of ocean inflow going into the model domain, and the models that they built try to show that. Otherwise, it's not a model that's really conceptualized properly. And that's explained multiple times throughout this proceeding, as is the issue with the layer 1 and the equivalent freshwater heads. Those are pretty much the same issue. Initially, the experts were going to do an 11-layer model because they were going to look to calibrate to equivalent freshwater heads. When Dr. Kincaid testified that we abandoned that, that's the collective, all of the experts. None of the models in phase 2 or phase 3 are calibrated to equivalent freshwater heads, which is why Dr. Kincaid said he didn't think it was necessary to have the layer 1 anymore. And instead, he modeled the connectivity with the ocean using the constant head boundaries. He explains in his testimony that CalAm functionally did the same thing by increasing vertical hydraulic conductivity at the ocean to create the same kind of connection there. So again, there's nothing wrong with that. It's not improper in any way. It's specific. It's perfectly acceptable in the modeling world. I'm not sure if there's anything else you really want me to address.
No, I appreciate that, Mr. Brochard, and your written submittal was very thorough. So that's the reason I don't have questions is actually because your submission was, I think, pretty quite detailed.
Thank you. The last thing I will just say, Mr. Osias had said that the models are uncertain and things are uncertain. And then Mr. Betts had said that their experts are certain. I would agree that, one of the main themes and the disagreements here is that CalAm's experts keep saying with absolute certainty things that are not certain. And that is a major issue. And that's something that we will be discussing in the closing brief. But I think that goes more toward credibility than it does towards, and the weight of evidence and the opinion than it does towards the admissibility.
Thank you, Mr. Brochard. Ms. Meisenheimer, please, if you have comments, please go ahead.
Thank you. Mr. Osias went sort of a little broader than the scope of the motion, and I think got into some of the themes of the case. And I just wanted to respond briefly. I think it is important at some point in this proceeding to take a step back and look at the context. And we do have CalAm, who are the proponents of this massive project, who are coming in and, not surprisingly, taking the position that there's a lot of certainty. We know what's going to happen. It's not going to cause harm. And that's a part of one of the steps they want to take to try to get to their project. But they are citing this project and the disadvantaged community of Marina that does not receive a benefit from this water. And at the end of the day, it is Marina's clean and affordable drinking water that is going to be put at risk. Everything we've heard in this proceeding, and there's been some tremendous efforts, there's been groundwater modeling, a lot of things, but I don't think that anybody can deny that there is uncertainty here. And that when we're putting together these groundwater models, it's based on the best available data, but we're connecting borehole logs that are distant. We're using AEM data. We're using pest programs to approximate K values, right? There's just a certain amount of uncertainty that is inherent in this process. And I think Dr. Kincaid has been very upfront about that uncertainty. and that's been appreciated by the city. But his critiques, as I believe you noted, to the extent that a critique that there is a lack of certainty is applicable to anything, it's applicable to both models, right? The uncertainties he's saying that are in the MCWD model are also in the CalAm model. The other point that's a little surprising was there's been a very big attack on MCWD's model as having uncertainties, and they've identified a few things here and there. But there's a complete disregard for the fact that CalAm's modeling also had errors and issues. And I think we saw that with how they did the recharge. And then they tried to do a recharge sensitivity that then they said that was wrong too. And then they tried to introduce an entirely new model at the very end of the proceeding that was excluded. So to the extent that if any errors are going to cause something to not be admitted, again, that strikes me as something that goes both ways.
Thank you, Ms. Meisenheimer. I think it's with that, it's
One
fair to,
response.
I'm sorry, I didn't see.
I
Mr.
apologize.
Good. Your microphone just was in and out. I was about to give you a chance to respond, so please go ahead.
Yeah, so on the thematic issue of this is the city of Marina's water, obviously CalAm cares about everyone's water. But this kind of comes back to something we suggested before. Marina Coast Water District and CalAm and Monterey were going to do a virtually identical project a little while ago. So if they're now saying they were going to poison their own people with water, it just makes no sense. The only reason we have another project is because they had an affiliation and that led to a felony, and then they no longer were allowed to participate. So the sympathy play of, hey, this is our people's water, they were going to be lockstep with us until that all dissolved before.
Thank you.
If I might, a very
So now we are
fundamental.
hold on, we're well beyond, but not only the motion, but also this question of uncertainty. So I do want to limit our comments. I'd like to scale back and just focus on the motion at this time. So Mr. Betts, if you have additional thoughts on the motion, and then Ms. Meisenheimer, if you have comments on that, then you're welcome to respond.
No, it was addressed. I just didn't want it to go unaddressed. So I understand. And going back to the uncertainty, I continue to say they're right. I mean, our people stand by our decisions. They're the ones that keep coming forward to say that their decisions and their interpretations are uncertain. And again, that was highlighted in their brief, page 8. They go on to tell you additional uncertainties. And when you have uncertainties, going back to the motion, that's not the type of evidence that should be admitted.
And Ms. Meisenheimer, you're welcome if you have anything additional.
No, I think I've said my piece. Again, I think to the extent that there are critiques about uncertainties, everything I read in Dr. Kincaid's direct and rebuttal testimony was that they applied equally to both models.
Thank you. And Mr. Burchard, I don't have questions, but I didn't want to pass you up. Do you have anything else to say?
On the motion, or do you want me to respond
On the
to
motion.
Mr.
Let's
Betts'
please focus on
testimony
the
from
motion.
earlier?
No, thank you.
Nothing more on the motion.
Thank you. I am prepared to rule on the motion. This is the motion to strike testimony of Dr. Kincaid in phase 2 and phase 3. I did have concerns about the timeliness of the motion with respect to phase 2 testimony, but I think that comes out in the wash because I'm going to deny the motion on other bases. So we don't need to get into that. First of all, the errors which Dr. Kincaid discussed and are discussed in CalAm's motion, I mean, it really, to me, it's the revelation that Dr. Kincaid is in fact human and his team is human was not a big surprise. And this modeling where, I mean, he's a professional. The CalAm's experts are professionals. Everyone has behaved very professionally and worked really hard. But I think some errors, given the time schedule, were unavoidable. The question is, how you deal with the errors, and Dr. Kincaid discussed those on the record. There may be I'm not saying he answered every single question anyone may have, or even that my team may have, although we will have a chance to ask those if we think it's important. These errors just are inherent. CalAm's experts in this proceeding made what we might, and I'm loosely calling them errors. It's sort of, you draft some, as a lawyer, right? You draft something and then you have things that are, I suppose, in errors. You fix them, you correct them, you work through it. And there just wasn't, in this proceeding, the time limits were significant and serious. And we're all doing the best work we can in the limited time that we have, and to get a response to the court in a manner that is timely within a reasonable period. We don't have unlimited time. So I do not think that these errors entirely undermine Dr. Kincaid's testimony. I think I don't think Cal-Am pointed to any fundamental concerns that would give rise to the level to say this testimony is entirely unreliable and shouldn't be considered at all. Certainly they should be considered with respect to the weight to be afforded the testimony. I wanted to reiterate here that one of the differences that I see in the role of an administrative hearings office as opposed to a court, and particularly as opposed to a court in which a jury is involved, is that the gatekeeping function is different. I know there's a lot of discussion about, with respect to the evidentiary code and expert testimony, the judge has a role as a gatekeeper. Here, my role is, to some extent, as a gatekeeper. I don't want complete, obviously, if testimony is completely unreliable and speculative, it's just not relevant to the proceeding. It's, and certainly isn't helpful and invites confusion. But really what I see the AHO's role is to bring all of the relevant evidence in and then do this assessment after it's admitted, do this assessment of what should be afforded more weight than others. We're not trying to gatekeep for a jury who might not have the expertise to really understand expert testimony and its basis. I'm not even in the same position as a judge because I have this wonderful team that I work with who has technical training and technical expertise, and it can help me understand some of this testimony. So it is a little bit of a different function than what I see as what happens in court. Given all that, I think this certainly, Dr. Kincaid's testimony rises to the level of reliability that's appropriate to admit the evidence, and then consider all of Cal-Am's objections and the errors that have been pointed out in this motion when considering how to weigh that evidence and his testimony in light of Cal-Am's, the entire record as a whole, Cal-Am's witnesses' testimony, the other testimony we received, the inherent limitations on modeling, that's a big part of this, the functions of the various models, what they're purported to do. I sort of wrestled a little bit on how to respond exactly to the choice by Dr. Kincaid not to use, I think the appropriate term is layer one, but the first layer of the model to go ahead. He had reasons for making that decision. I think it's neither here nor there at this point in the proceeding. Say, well, it would have been better, we could have had more apples to apples if he'd done it the other way. He had reasons for making a decision not to, I don't want to say not to follow that instruction. I mean, maybe it's appropriate to say not to follow that instruction, or he thought it was appropriate to deviate from that instruction. I mean, that's something, again, we'll take into consideration when assessing his testimony and his modeling work. So I think based on all of that consideration, I am going to overrule or deny Cal-Am's motion to strike, bring the testimony in with the understanding that it's the work of the AHO to then weigh that testimony, and you're going to help me in your closing briefs and your draft reports of referee, help me understand how you think I should weigh that testimony in light of everything that was raised in the motion. So with that, the motion is denied, which I think leaves me to turn back to you, Mr. Betts, to ask if there are any additional outstanding objections to the exhibits offered into evidence by Marina Coast Water District.
No.
Thank you. So with that, Marina Coast Water District's Phase 3 exhibits are accepted into evidence. That is Marina Coast 163 through 169, 171 through 178, and as noted, 175 and 176 are second revised slides. So we will try to be careful to get those right. With all of that, is there anything else? I would like to talk about January dates in a moment, but is there anything else procedurally, whether it's related to exhibits or anything else other than discussing holding January dates that we should address today during our time together?
This is just a quick
Mr. Betts.
clarification. By not objecting to the remainder of Marina's exhibit or Marina Coast Water District, we're not saying that they are indeed reliable. By any means, we're not saying that they're admissible for the state court proceeding. Just for this particular proceeding, we're not raising additional objections to admissibility. We may challenge them on other grounds. I think I think everybody understands that, but just for our record, I apologize if I'm cluttering it. Just want to make that clear.
No, thank you, Mr. Betts. I certainly understand the desire to and make sure that's clear in the record. So thank you.
Thank you.
So here's what I'm thinking with respect to January dates is that I will give you some possibilities from the AHO, and then you can meet and confer amongst yourselves and get back to me. I'm not going to give you a deadline, just some reasonable time when you figure out what dates would be appropriate. I wrote them down somewhere. So we were looking, what I'd like to do is ideally hold 2 days. Hopefully we wouldn't need 2 days. We may not need any days, but I would like to hold 2 days in January. Then we can kind of pick one or the other for the experts to return in case the AHO has questions. The idea is that the AHO would send our questions, or at least very specific topics, in advance, at least 2 weeks in advance, so that you would know and your experts would know what we were going to be talking about. So it wouldn't be a surprise. But I was looking at the week of January 15th. So the days that are possible for the AHO is January 15th, 16th, or 18th. And then the following week, January 22nd through 25th. And I think ideally, if it's possible to meet and confer and come up with 1 day each week, that would be an ideal as something acceptable. Then we could schedule out those 2 days. If we need them both, we can use them. If we only need one, we can use one or the other. But I will leave that. I think that's something you can do. We can do offline, or you can do offline, and then select someone to submit that to the AHO. If you aren't able to come up with dates, we'll have to work on that. I mean, I would have to pick something, but I assume you all have worked very well together to get us here today. So I think you can do that. Mr. Osias, I see you came off mute. Do you have something on the dates or anything else?
Only that I appreciate your confidence, but for us to, and when we have to meet and confer, we do. And when
Yes,
we can find things to agree upon, we do. It has always been helpful to have a reporting deadline to you.
okay.
Rather than January 14th is the last day that
No.
we can tell you. And
You're
so
right.
all I'm
I
going to
don't wanna
suggest
hear-
is
Yep.
pick a date, we'll meet it.
I want to know by October 31st what days in January you would like to meet.
Thank you. At least I
Thank
saw
you.
Mr. Brochard smile in response to my comment.
I appreciate your frankness and letting me know how I can help all of you. I appreciate that. I will issue a so it's maybe homework for the AHO. I will issue a ruling. I may just issue an email because this may be the only thing documenting the extension of time, just so we have it in writing on the closing briefs and the part 2 of the draft report of referee. And then once we settle on possible dates in January, I will issue a notice for those, but it's a tentative notice in the sense of please hold those dates, and then I will inform you in advance, at least 2 weeks in advance, whether or not we're in fact planning to meet on those dates and what the topics would be or the specific questions would be for the experts. Mr. Wilkins, I see you have your hand up.
Yeah, just a clarification on these dates. As I understand it, you want all of the experts, both Marina Coast, Cal-Am, and the cities, to be available on these dates. And I just want to make sure that's right, because if we have like one expert that's not available, having had no discussions with them at all about January, is that a problem? Just are we trying to find ideally dates that every expert's available, or or are you thinking of something different? Just wanted to make sure I understood that.
Let's see. It's a good question because I hadn't. First of all, let's narrow down to the phase 3 experts. So at least that might be implicit, but I will narrow that down. I'm just talking about the phase 3 experts. I think ideally we'd have everyone available on one day because, but there may be some back and forth. But if you come up with 2 days and the expert is available at least one of those, just let me know in the submission by October 31st. I think that's workable. I mean, if we can't figure anything else out.
Thank you. Yeah, hopefully that we can find a day, 2 days that works for everybody, but I just wanted to make sure that was
Right.
what you wanted.
Yeah, thank you.
The notice that, yeah, I was just gonna say, when you send out either topics or questions, and I'll use an example that's the easiest one. If it has nothing to do with variable density, it's less critically important that Mr. Tietze be there.
Yes,
So, you know, I think the goal should be to get everybody there because they need to hear each other. But you know, if that was like an unavailable person and you had no questions about that, that's probably
work
shouldn't
fine.
be.
Yes, I agree. I think we can work this out. Good. No, so I'm looking to the room to see if there's anything else we need to address today. I'm not going to say this is the close of the hearing, but we are getting close because we may meet again, which would officially, of course, any testimony that we would elicit from the experts would be part of the evidentiary record if and when we meet again in January. But is there anything else we should discuss before we break and probably don't see each other again until January?
Right. I think this was resolved, but let's make sure it is because we're all together and Mr. Brochard gets a lot of credit for having ordered these. But we now have, I believe, submitted all of transcripts as transcribed by a court reporter for all hearing days. And to the extent people want to use oral positions, testimony, whatever, we should be citing to those transcripts. Is that the practice that will work best? And
Yes.
and just day, page and line as we would in a normal court proceeding. I don't think they have exhibit numbers.
They're already uploaded onto the AHO's site, and you're correct, it's by day.
Yes, I think that's Mr. Asais, as you described it, that is appropriate. What I would say is that the video recording will be, at least according to the AHO, the official record if there is a conflict for any, I mean, hopefully there would not be, but a conflict between the transcript and the video recording would control. But these transcripts, which I very much appreciate having because they're much more accurate than the Zoom generated transcripts, please don't cite to the Zoom generated transcripts, and there's no need to cite to the video recording. I think we can all agree, unless someone has an objection, from my point of view, let's just cite to the transcripts that were created, I guess is the word, by the court reporter from those video recordings.
Perfect.
And thank you, Mr. Brochard, for those. And thank you for, yeah, I believe I think they're all there. I know most of them are there, but I think they are all there.
I think they're all there.
And then just to confirm also on the AHO's to-do list, we need to update our exhibit list to reflect what we understand is admitted into evidence. And if there are any concerns or in terms of you think there's an inaccuracy there or we've missed something, please let us know in writing and we can decide how best to deal with that. Whether we need to talk about it or whether it can be dealt with just in writing. Is there anything else to discuss today? Well, with that, thank you very much for convening today. I appreciate this. Thank you for your patience in working through these issues. And I will see you when we meet again. We will be in touch in writing, and we may see each other in January. And I hope if I don't talk with all of you, you have a wonderful holiday season and wonderful winter.
Thank you.
Thank you.
Adjourned.
Thank you, you too.